My name is Liam Harkness. I am the Treasurer of the Scottish Libertarian Party. When I'm not doing that, I work as an accountant, but previously I studied law when I was at university. And what I thought I'd do tonight is discuss the topic of liberty under threat, but with more of a legal slant on it. I thought that might be slightly more interesting, simply because it's not the sort of thing you're necessarily going to hear every day, and the vast majority of material on the internet does not take that approach. With the legal thing in mind, I thought I'd start with a quick set of questions for you and see how, try and break the ice here. In the last 20 years, there have been hundreds, if not thousands, of new criminal offences created in the UK. Now, I have to say I'm going to largely talk from the Scottish perspective because we've got Andrew here, but I thought I'd cast net a little bit wider for this section. I picked some of the most ridiculous laws from the UK from the last 20 years. So with that in mind, I want to see if any of you can tell me which, if any of these laws I made up and which are actually genuine laws. So here we go, right? Selling types of flora and fauna not native to the UK, such as the grey squirrel or Japanese knotweed. To willfully pretend to be a barrister or a traffic warden. Disturbing a pack of eggs when instructed not to by an authorised officer. Offering for sale a game bird killed on a Sunday or Christmas Day. Selling Polish potatoes. Or scallop fishing without the correct boat. So which of those, if any, did I make up?
The egg one.
Yeah.
None of them.
None of them, you're right. All of those ones are utterly ridiculous laws, criminal laws created in the last 20 years in the United Kingdom. So with the topic of being liberty under threat, my view is it's not necessarily appropriate to take the view that it's under threat in the sense that it's a binary thing. It's not a case of you have liberty or you don't, although if you're released from prison, it may well seem that's the case. But for most of us, it's more of a case that liberty is a sliding scale and you either gain a little bit with some things being legalised, or you can lose some as things are criminalised. And the question really is, which way are we going? My argument is going to be that sadly, given the example of the ridiculous laws that we've been creating, we are slowly chiseling away at our liberties and drifting further and further towards totalitarianism. We're not going to be facing a firing squad overnight, and people would rightly laugh at us if we said that, but we are moving in that direction, I feel. Certainly we're not moving towards a free country. So with the Scots Law Principles in mind, I thought I'd introduce a few ideas. The first one, most you'll have heard of, is the presumption of innocence. That says that everybody is innocent until they're proven guilty, and we demand a very high standard of proof that is beyond reasonable doubt before we convict, and that people, you can't just throw people in jail for no good reason. Another principle we have is the idea of no case to answer. So this is codified in Section 92 of the Criminal Procedure Scotland Act, 1995. That's a very sad point, but there you go. The basic concept of that is pretty essential. That says you do not have to defend yourself to any spurious allegation. So I could just throw some insult out there and say that you stabbed my wife, and the police are not going to take you away and make you answer for that right away without any evidence. If I just make a spurious allegation, there's no way that you have to simply answer for that. And that's quite important, otherwise you spend your entire life tied up in litigation. Unfortunately, what we see at the moment is a general attitude away from appreciating those principles and more towards tyranny. A good example of this that we've seen is with the likes of Brett Kavanaugh. This is a man that's accused of having done something, we're not sure what, at time and place unspecified, to one person who can't remember any other details. And he doesn't know anything about it, because he can't remember if it happened, and he's certainly not been given any help to to remember. Nevertheless, he's been expected to respond to those allegations. And most people seem to think that's perfectly reasonable. The whole cries of "we believe her," which are really rather moronic in my view, given how little evidence she's presented. But it's indicative of the pattern we're seeing, and it's not just in the US, but in this country too, where people are inclined to support the idea of guilt just because somebody has been accused of something. And that's a really worrying development. The reality is that Brett Kavanaugh should never have had to face any of those allegations, so completely spurious. The woman in question should have taken this to court. But there's something more about that I want to raise, and it's quite an interesting point. So in Scotland, and I presume there's a similar doctrine in the USA or in other countries, but certainly in Scotland we have what is called the Murov Doctrine. Now the Murov Doctrine says this, that, it was basically the guy Samuel Murov was on trial in 1930. 19 different girls had made accusations against him, but they were all separate accusations. None of them had corroboration, there was no witnesses, it was just him in a room alone having done something to them. The court decided, or rather the court held, that that could be used as corroboration, that they could cross-corroborate. The way this works is, if I go to the police and make some very specific allegation about someone like Stephen here, and I say that he whacked out in front of me and then made some obscene comments, but they were quite specific comments. The whole pattern was quite ritualised. Was quite ritualised. If I just make that accusation, it's going to be difficult to prosecute. However, if unknown to me and without having spoken to them, another person comes forward to the police and makes very similar allegations, and then another, you start to have a pattern of information there that people keep coming forward saying the same thing, which we could never have possibly coordinated our stories, and so there must be something more to it, and that could be used as corroboration. Now, why do I mention that? I mention it in the context of Brett Kavanaugh's accusations. If Christine Ford, and if the Me Too movement, and all its champions in the USA and in Scotland had really wanted to see justice done, they would not be going out and shouting it on TV. Because once she stood up in front of the cameras and made these allegations, any specific piece of information that she had that could be used to cross-corroborate is gone. Because now anybody can come out and repeat her story and the police can no way rely on it. What really needs to happen is she has to go to the police in confidence and say something quite discreet and not go and spill all the beans. But the fact that women are tweeting Me Too, are being encouraged to come forward and make these allegations, not only is the feminist movement and those on the left not going to secure any conviction and it's just wasting everybody's time, they're actually making it harder. They're making it harder and damaging the possibility of real justice. Now, why would they do this? Well, it's quite simple. They're not really interested in justice, not that we would see. Social justice, maybe. Political ends, yes. But not what we would recognise as real justice. And to me, that's an example of where we are drifting away in our ideas, away from a liberty-focused approach where there is the presumption of innocence, there is principles no case to answer, to simply a lynch mob mentality, pursuing these witch hunts. So the other issue I wish to pick up on here is Double Jeopardy. Now, most of you will know Double Jeopardy. There was a film starring Ashley Judd and Tommy Lee Jones by the same name. It kind of sums up the principle quite well. She is accused and convicted of murdering her husband. It turns out that he had faked his own death, and therefore she is free to go and kill him again, because you can't be tried for the same crime twice. There's a principle behind that. The principle is quite straightforward. You're arrested, you're taken to court, you're remanded in custody until your trial, you're held by the police, you're brought before the court, chained to the bailiffs, you go through the trial and the judge acquits you, finds you not guilty. You walk out, you're halfway down the steps of the court, a free man, a policeman comes up to you, arrests you, charges you with the same offence, drags you back inside and remands you in custody until the trial. And we can keep doing that over and over until they get the right conviction. Well, It's obvious to see how that is an affront to liberty. The principle of double jeopardy is something we've always had in Scots law up until 2011, when it was done away with. The real reason it was done away with the catalyst for it was the trial of Angus Sinclair, who was charged with what's known as the World's End murders. Now, Angus Sinclair was a scumbag murderer who was already in prison, but enough new evidence through DNA or whatever came to light to charge him with these murders. It was a big case because he'd lain unsolved for 30, 40 years, came to court, prosecution mucked it up. The defence made a plea of Section 92, no case to answer, and the court accepted it because the prosecution hadn't presented any clear evidence that he was guilty. They just ballsed it up, basically. So he was acquitted. At that point, Alex Salmond, who was First Minister, came out and immediately said, well, we're going to change the law to make sure that Angus Sinclair is arrested, tried, and put in prison again. Now, that should strike fear into anyone's hearts, because despite the fact that Sinclair is a scumbag who deserved justice, using that as a context to strip away the rights of everybody else to not be tried again for the same crime is throwing the baby out with the bathwater. Not only that, it should scare any of us to see a politician turn around and say, and you, we're going to change the law to put you in prison, because we want to put you in prison. I don't care that you were acquitted last time, we'll decide you're going to prison. Well, that shouldn't be happening. Unfortunately, they've done that. Now, the reason for getting rid of double jeopardy may well be justified in this case, but for all eternity now, or at least until some government feels that supporting liberty a little bit more, we're going to be left with the consequences of this. And although they put in caveats, and it can only be used in certain circumstances, it's pretty clear that they've crossed the threshold here. They've now said, okay, well, you don't always have to have it. That's not a hard and fast principle. And I think we'll see in time, as threats to liberty increase, that more of these caveats will be taken away, and there'll be fewer and fewer restrictions on the ability to try ad nauseum for the same offence. Another thing you might have heard about in Scotland is corroboration. Now, corroboration is the Scots Law Principle, which says you need two sources of evidence for in order to convict. So a confession itself isn't enough. You need something extra. That's a safeguard against spurious accusations and he said, she said cases where the court is simply stuck with one person, one witness saying he raped me and another person saying no, I didn't. Not every legal system has corroboration, but it must be seen within the context of legal systems as a whole. Other legal systems have different checks and balances. This is simply our protection. So, as in a car, you might have side airbags, or you might have, strengthened roll bars instead of it, or some other defence. And the car mechanic would be pretty clear to tell from that poor analogy. But it has to be taken within the context, and unfortunately, it seems the government is all too willing to get rid of this crucial piece of protection of your rights. Now, why do they want to get rid of it? Well, they've decided that conviction rates for rape and sexual assault are too low. And as is the case in today's social justice world, poor crying women have to be believed in all instances, regardless of whether what they say is nonsense or not. Now, that's been the motivation for wanting to get rid of corroboration, and it's something which has been advised against, but it still looks like the SNP will try and push that through at some point. One thing that's very important to realise here is when they say conviction rates are too low, that's an impossibility, because it is a question of fact. The jury is there to identify the facts. The judge, his job is to answer questions of law. The jury is there to identify the facts. Not politician, not you and me, not person reading the newspaper or a bystander or somebody else in the court. The jury are specifically charged with finding the facts. They are excluded from being bombarded with other information which may sway them, and they're told specifically what to consider and what not. So that puts them in a position which is different from everybody else, because we all carry our prejudices and things. To be sure, they will have their prejudices as well, but they are encouraged to limit them, and they're in a uniquely entrusted role of deciding on the facts. So when they come back as a matter of fact and say there was no rape, then the person there who was accused is innocent. He was innocent before, they have not convicted him, and he remains innocent. For a politician to come round and say that the conviction rates are too low is to say that innocent people should go to jail. A politician is not in a position to say how many of them were actually guilty and how many were not, because that is the point of the jury has already determined that. So when politicians start coming out saying the conviction rates for anything are too low, then you just know that that is nonsense, and that any desire to increase conviction rates should just be seen as what it is, a clamour to satisfy something other than justice. Again, social justice in this case, pandering to the feminists and whatnot, but it's erosion of your rights, and it's a threat to liberty to see them attempt to remove corroboration. Of course, no discussion on liberty and Scots law could be complete without some discussion around the curious case of Count Dankula and the Nazi pug, the conniving canine or whatever. I'm sure you've all heard about this. Marcus Meehan was prosecuted under section 127, I think it is, of the Communications Act 2003. Now that applies across the United Kingdom. It's not unique to Scotland, but this case was in Scotland and has become known worldwide now as another instance of utter stupidity on the part of governments. As you're well aware, he deliberately trained his girlfriend's dog to make a Nazi salute to wind her up. And he says quite clearly at the start of the video, he says, I thought of the worst thing in the world possible, so I could get the dog to do to wind her up. But unfortunately, the judge determined that this cannot be, you cannot view jokes in context, apparently, which seems ridiculous, but there we go. The fact is that the Communications Act is just another example of some of the bizarre laws that we've seen coming through. Some of them we discussed earlier at the start. In fact, within the Communications Act and many other acts, there are a whole series of offences created which are called strict liability. Now, strict liability differs from normal criminal laws. A normal criminal law requires two elements. One is the action. So let's say it's a jacket, I go over there, I think I pick up somebody's jacket, I take the coat away from somebody and it belongs to somebody else. So that's the action of theft. The mental element is also crucial. What's required is a guilty mind. I have to deliberately take somebody else's coat, knowing it's somebody else's coat, with the intention of depriving them of it. If I go and pick up a coat because I think it's mine, because we have got this exact same coat, Andrew and I have got the same coat, then that's not a crime, it's nothing, it's just an accident, it's a mistake, it's a misunderstanding. What makes the difference there is the mental state. Problem is, that makes it a little bit harder to prosecute, because if you want to be charged people with crimes, not only do you have to prove the act, you've got to prove the mental state, and that's too difficult for governments, they can't really be bothered with that. What they much prefer is the idea of strict liability. Now, strict liability says you're guilty just by the circumstances you're in. So, for theft, the example would be anyone who causes themselves to be in possession of another person's coat is a crime. And in that case, any accident or mistake becomes a crime. Now, there are other examples of that. A lot of them you see with motoring, speeding. Whether you intended to speed or not, doesn't matter. If you're over the limit, that's a crime, flat out. But they try and throw it in other cases. Communications Act is an example of it. That is taking away from basic principles of law which are there for your benefit. That if you did not intend to do anything wrong, you should not be getting punished. But now they can create a whole myriad of laws, some of them very stupid as we've seen, and for all intent, I don't know the exact specifics of those things, but it may well be the case that if you were selling Polish potatoes, you're guilty without the mental component. Now, until I looked that up, I'd never heard of that as a crime. I'm sure nobody in this room did. But you can just imagine that if you're just Lord knows the circumstances you find yourself in possession of a grey squirrel or a load of Polish potatoes. But if you tried, if you were having it with selling them and the old bill comes along and says, sorry mate, that's a crime, so I didn't know anything about it, apologies officer, that won't cut it. Say no. Doesn't matter you didn't try and commit a crime. Doesn't matter that you're the most law-abiding citizen in the world and that you go in and clean up the church hall every morning and bathe the feet of the homeless. That doesn't matter. You were found in a circumstance there, and whether how good your clean your mind is doesn't matter. We're going to arrest you. Now the effort to pursue those kind of laws at the expense of traditional criminal law is another example of government chipping away your liberty. Now, as I say, I view it very much as a sliding scale. I don't see it's one minute you have liberty and the next minute you wake up with none. But every time they do something like this, like creating additional strict liability offences, like chipping away corroboration, taking away double jeopardy, all these things are little changes to law which go far against basic principles of Scots law. And they get away with it in part because they use cases like the World's End murders to try public outcry that something must be done, and then they take that opportunity to act. But they take the opportunity to act there, and it then applies for everything else. And they keep doing that, they keep chipping away at your rights. So to sum up, because I don't want to run on for too long, I don't think that we are living in a totalitarian state. But as I've demonstrated with the laws, some of which are Labour Party, some of which are SNP, the Tories in Westminster are guilty of their thing. Politicians of all hues have been busy over the past 2 decades undermining the foundations of liberty. In particular, have shown that they are willing to go against fundamental legal principles in order to push through legislation to achieve their aims. Now, not everything that they enacted was necessarily done for malicious reasons, nor is it without merit. Corroboration, for instance, they may well genuinely see that it is just far too difficult to prosecute certain offences when people start arguing without consent. But the fact is that there are drawbacks to these, and every time we do a little bit more of those without any sort of compensating check or balance for the side of liberty, we're drifting further and further away from liberty and further towards tyranny. All these things give the state more power, and as Lord Acton famously put it, power corrupts, absolute power corrupts absolutely. And if they give the state the power to prosecute you without needing to prove you've got a guilty mind, or by giving them the power to keep retrying you and rearresting you as much as they like, then we are going to end up much closer to a police state than we are in now. So, we're not in a police state. We're not facing the fire squad tomorrow, and largely we can have discussions in this room that are not going to be reported by a spy or Stasi, though some of you look a bit shifty and what.
Are you sure?
But if you look back at the last 20 years in the direction of travel, it's certain that we are moving away from liberty towards tyranny. I hope that what I've covered here is vaguely interesting. I have tried not to tread the same ground that Andrew will probably tread on, or to cover topics that you will find easily on YouTube. I've tried to give you something that's a little bit Scottish specific and a bit of flavour there that you can take away next time you see a politician arguing for any of these laws, that you can say, well, hang on a minute, there are drawbacks to that. So I hope that's been worthwhile for you, and thank you very much for having me here.
Time is precious, but what do I know? Been to places you